When a person is charged for an offence, that person is carried before the court. If that person enters a not guilty plea, well, even if the person enters a guilty plea, but the court doesn't want to pass sentence then and there, the court then has to consider whether he or she is going to grant or refuse bail to that person. In this video, we're going to be speaking about those factors that the court considers and reflects on when they're going to either grant or refuse bail. Sounds interesting? Let's get into this video now. Before I get into those factors, for those persons who may not know what bail is, I would define bail as a temporary release of a person who is charged for an offence, with that person given an undertaking or the understanding that that person is going to return to court whenever they have to do that. When a person is charged for an offence, remember that that person is presumed innocent until proven guilty, the presumption of innocence. If you didn't check that video out, you should look at it. I'll leave it at the link right above there. Which means that a person is to be seen as though they did not commit the offence or the alleged offence until that person either pleads guilty or the person is found guilty by the court or by the jury if it's a jury trial. When I look at the Constitution in Trinidad and Tobago as well as some other Caribbean islands, there appears to be what could be described as a presumption in favour of bail for the accused person. There's a case, Augustus Steward. I'll leave the case in the link below. You can have a read on that very interesting case where the judge as well made that mention that there's a presumption in favor of granting bail for persons because it's a constitutional right. Now, there are some non-bailable offences in the Bail Act in Trinidad and Tobago. Remember that this video is being made in February 2021. There may be some changes in the law, there may not be any changes in the law because this particular issue as to whether murder is a bailable offence is before the courts now. So there may be some changes. If that happens, then we'll speak about that accordingly. But let me tell you some of the non-bailable offences right now in Trinidad and Tobago. One, murder. The other being treason, piracy or hijacking, or any other offences where the penalty is by death. So those are the non-bailable offences. And remember, if you didn't see that video where I went in the streets and I spoke to persons regarding bail and non-bailable offences, and so you should check that video out as well. I'll leave it right up here for you guys. As mentioned earlier, there's a presumption in favour of granting bail to a person who is accused of an offence. So whenever you go before the court and the prosecution is asking the court to deny you bail, they must come with some very good reasons. Now the law says that the court shall use its discretion in denying bail under certain circumstances, which means that the court, in considering all factors and different circumstances, would put its judicial mind, as we describe it, to determine whether they're going to grant or refuse bail. Let me give you some of these points. One, the law says if it's for the defendant's protection, then the court could deny bail. Let's say, for example, this person is charged for a particular offence and the prosecution then puts before the court that they have certain information that this person may be killed or harmed if they are to be released on bail. So there was a death threat or something for this particular individual, then the court may refuse bail. But the prosecution will certainly have to have sufficient evidence to prove that. The law also says if it's for the child or a young person's welfare, the court may just refuse bail in those circumstances. Further, the court says the law says if a person absconds bail, meaning that they were granted bail and then they refuse to come to court when they're supposed to come to court, then the court could refuse bail in such a circumstance. Another would be if the person is serving a sentence. The person is in custody already and they're charged for an next offence or so, then that person could be denied bail. Another one would be there's not enough information before the court for the court to consider granting bail or not. Say, for example, the court needs to get the criminal records of this person, meaning all of the pending matters and former convictions or so of this individual. If the court doesn't have that, the court may not release that person or grant that person bail until they see that document for them to consider whether they should grant bail or not. A prime example of this one as well is where a person may be in custody for a particular offence and the virtual complainant, the alleged victim, they are in the hospital and their medical condition is really bad, deteriorating rapidly, and the prosecution is concerned that the person may pass away. As such, if a person is charged for an offense of, let's say, wounding with intent, the prosecution may say that the person is in really bad condition and the person may pass away, and as such they may want to charge the person for murder. So in such a case, the court may refuse bail on those kind of circumstances. Another area, general area, is where there must be substantial grounds for the court believing that the person may fail to surrender to custody, the person may interfere with witnesses or the course of justice, or the person may commit an offense while on bail. I hope you got those. Now, in considering that, whether there's substantial grounds for believing, and here's the kind of word, substantial grounds for believing. So the prosecution must come with sufficient evidence to actually show this. The court is going to consider different factors. The court is going to consider the nature and the seriousness of the offense. They're going to consider the character of the accused person. So is this person well known? Is this person respected in society? Does this person have a stable job? Does this person have a family life? All of that also speaks about the social ties, which shows that this person is most likely going to remain in the jurisdiction until the matter is completed. Where does this person go to school? Where does this person do their banking? Are they involved in any social groups? All of that to just show that they are connected to society. The court will also look at the antecedents of the person, the former convictions, if they have any convictions, and pending former convictions, I should say. Now, attorneys, defense attorneys, what would normally be said is, even if the person has convictions or so, what the court would look at, what the advocate would put forward, is that that person was on bail in those offences, and the person fulfilled their bail obligation, which means that the person came to court when they had to, and different conditions, which I'm going to speak about in my next video. So the court looks at that as well. The court looks at the strength of the evidence before the court and other factors. Now, those are just some points. If you speak to another attorney and you obtain independent legal advice, you'd get some more details regarding this. Remember that these videos aren't legal advice, so I can't give you in its entirety what the factors would be, because every case would be unique. So this is why I'm saying you should always seek legal advice. These videos are just here to share information regarding the law, and I'm hoping that they're very useful to you. If they are, just leave a little comment down there. Let me know that you're getting value. And let me just use this time as well to say hello to Michael from Grenada, who I spoke to recently, and he's saying that these videos are very helpful for him. I'm very thankful to you guys. Thank you so much. Now, this is a to be continued video, because there's some other points I want to mention regarding bail, such as the type of bail, what are the bail conditions as well that the law speaks of, as well as how do you review bail if it is that the prosecution wants a person's bail to be revoked, or if a person was denied bail and then wants to apply for bail. What do you do? What do you do? So we'll talk about that in my next video. Check out some of my other videos, you guys, and thank you so much for your support. We will see in my other video.